Hello and welcome to Holland Estates. I'm Stuart Clark.
And I'm Garrett, Horrocks.
And I'm not quite sure what number episode this is, but I'm sure someone's told you. If not, I'm not sure numbers matter anymore. As you can still see, we are coming to you from our Zoom hangouts. We are still remote working due to the pandemic, although I'm very happy to be podcasting with you today, Garrett. So I mean, we have a topic today, which is kind of an interesting distinction, which makes you look like you know what you're talking about, I guess, for nothing else. And that is the legal distinction between a litigation guardian versus having to get a representation order when you're dealing with unborn and unascertained beneficiaries. And so, I mean, the concept of unborn and unascertained beneficiaries is something that we have to deal with semi-frequently in the estates world. And that's often because you'll see, wills or trusts or something like that, which provide for gift overs to a class of beneficiaries that include a person's issue, children, grandchildren, great-grandchildren, etc., who may not yet be born. So how do you deal, if you're dealing in a will challenge or some other, litigation revolving around an estate or trust, how do you deal with people who, although not yet in existence and may never actually be in existence, have a hypothetical interest in this lawsuit? And that's where the distinction between litigation guardians and representation orders come in. Do you want to give a basic rundown, Garrett?
Yeah, so a litigation guardian, maybe to back up a little bit, is someone who acts on behalf of a person that obviously is in existence, and generally for a party that's with someone who's under disability. So whether they're a minor, whether they've been declared incapable of managing their property, they're essentially a person in existence who is deemed by the court to not be able to make decisions with respect to litigation, be it because they're a minor or they're incapable. So someone has to be appointed, or a party or an individual has to be appointed on that person's behalf to essentially step into the shoes of that incapable person and run the litigation on their behalf in terms of retaining a lawyer, receiving or agreeing to instructions from that lawyer, asserting all the claims on behalf of that person, and they're just generally making decisions as to how that litigation is run. So they really are stepping into the shoes of that person. And typically in our case, at least in the states and wills and states context, it's often in the case of a minor beneficiary potentially under a will. If a beneficiary to that of that will potentially brings some litigation, that litigation may impact the interests of that minor beneficiary, and so someone needs to step into their shoes to act on their behalf and to make sure that their interests are protected, because the court takes interest in people who can't advocate for themselves, possibly even more seriously than those of people who can advocate on their behalf, because they're not able to convey their own voice, and so the court has to take special care to ensure not only are their interests protected, but there has to be the appearance of those interests being protected as well.
Yeah, no, exactly. And so as kind of Garrett alluded to there, the basic issue, so say you're in a will challenge and you have gift over to issue, which could include minor and unborn people who don't exist. Well, in that situation, typically, if there's a minor beneficiary, you're gonna move to appoint a litigation guardian, often the children's lawyer, to act on behalf of the minor interests, and then you can deal with them on their behalf. And there's a process that's kind of set out in the rules for how you deal with them. If there's a settlement, how do you approve it on their behalf, et cetera, et cetera. But then there's the distinction of, well, can you appoint a litigation guardian for minor and unborn and unascertained, I should say. And the issue there, this has kind of come up recently a couple times, where I know I've heard people from the children's lawyer speak. They basically said, look, we're not sure that a litigation guardian can be appointed for someone who's not yet born, because the rules kind of contemplate that it's a party under a disability. And if a party who's not yet born, are they in fact a party, right? It's kind of an existential question, crisis. Do I exist if I don't exist? Can I be a party if I don't exist? And if the answer to that is no, can they act as litigation guardian for someone who's not yet born? Should they instead move under, which is Rule 10, which is the appointment of something called, it's called a representation order, which basically contemplates that the court can appoint someone that kind of akin to a litigation guardian to represent the interests of, in this case, unborn and unascertained people, much in the same way as a litigation guardian.
And typically that's in the context of at least in my experience, primarily motions being brought for approval of settlement on behalf of unborn and unascertained beneficiaries, because often that class of persons isn't necessarily going to be named as a party to a piece of litigation. Their interests will be impacted by any settlement reached by any of the parties to litigation. So naturally, they or someone on their behalf have to be put on notice of any motion for settlement, because I don't want to get into the weeds here, but any settlement entered into on behalf of a party under disability or an unborn or unascertained beneficiary is subject to approval of the court. again, it comes back to the maxim that the court has to seem to be protecting the interests of those who don't have their own voice, essentially. So typically, a representation order will be obtained when a settlement's been entered into, the interest of an unborn or unascertained person or class of persons is impacted by that settlement. And essentially, we just need someone to be able to sign off or to look at the settlement and say, this is a settlement that I think is in their favor or is not in their favor, and I'm happy to approve on their behalf. It's still going to be, again, subject to a judge signing off on it, but it just gives that extra layer of security that someone has or is acting as a voice for those who don't yet exist and obviously can't act for themselves.
And the process for both a litigation guardian and a representation order are substantially similar. I mean, one is governed, so litigation guardian under Rule 7, representation order under Rule 10 of the rules, and both contemplate this process by which, what you have to do to get appointed, and once you're appointed, if there's a settlement, how do you approve it on their behalf? And you could easily see a scenario where there are both minor beneficiaries and unborn and unascertained beneficiaries, such that, so in that scenario, maybe the children's lawyer is getting appointed both as litigation guardian for someone who's actually born but a minor, and then has a representation order for the future class of beneficiaries. But you need both, right? You can't just do one. You can't just say, I want a litigation guardian for everyone, because if you want to look like you're doing, what you're doing, and if the children's lawyer is kind of paying attention here, which it seems like they are more and more to the distinction between litigation guardian and representation order, they don't have authority under litigation guardian to approve a settlement on behalf of people who aren't yet born. So if you want that extra safeguard of that settlement binding future generations not yet born, you're going to need to move under a representation order to get that done.
Yeah, I mean, it's a bit, if we're being honest, maybe a bit of an artificial distinction because the rules are substantially similar. It just, when do they become involved is typically the salient difference here. Litigation guardian is typically going to be involved from the outset in most cases because these people are in existence. They are potentially named as parties, whereas the unborn and unascertained aren't, but their interests are impacted later on. So you may need to get a representation order to just kind of put a bow on everything and tie up any resolution. So the rules are going to be substantially similar in a number of cases. But as you've said, I mean, it's important to look like you know what you're talking about, especially if you don't want the children's lawyer to have any comments about how you're approaching the situation.
My goal in life is look like I know what I'm talking about. It is kind of an unofficial distinction maybe, but it's an important thing to pay attention to. And it makes you look like you know what you're talking about, which is always a fun thing to do. So that kind of makes me jump next to my next kind of thought, which is litigation guardians more generally. This is kind of an aside, kind of smaller point to our more large discussion here, the distinction between the two. And that is just, a litigation guardian, because a question that I get multiple times a year is, hey, I'm power of attorney for my elderly parent or someone like that. My parent's still with it, and they have a potential claim against someone else, usually an evil sibling or something like that. And I want to bring a claim on their behalf. But I'm worried that the stress involved with that claim may be too much for my parent. I don't want to subject them to having to be examined. Can I, as power of attorney, just bring that claim on their behalf and basically insulate mom or dad from the claim? And the answer to that, unfortunately, is probably no. For the same reason we've talked about before, litigation guardians can only be appointed in circumstances in which someone's actually incapable, a party under a disability. So if you are still capable, mom or dad is still capable, even if they gave you a power of attorney, the claim can't be brought by you as litigation guardian. It's going to have to be brought by them personally. Although we can get crafty with solutions with, where, hey, you can give us direct instructions as power of attorney as long as mom or dad are fine with it. At the end of the day, they're still going to be involved in the claim. And it's kind of important to always keep in mind saying, look, the litigation guardian can only be appointed in a very general sense when someone is incapable, whether because they're a minor or because of legally incapable. Otherwise, you got to represent yourself.
Yeah, I mean, there's a very solid reason as to why litigation guardians are appointed. Right? I mean, you're not typically looking to appoint a litigation guardian for any strategic reason or for any strategic advantage. I mean, it is very much to ensure that the interests of parties who can't act for themselves do in fact have a voice in court. There's obviously concern about litigation by proxy and whether and the fact that someone who's not incapable should have someone litigate on their behalf. That's obviously a huge concern, and it delves away from the issue of why litigation guardians are appointed in the first place. I mean, there's a very serious concern that the court needs to ensure that all parties to a piece of litigation have a voice, and just being able to act on someone else's behalf just because they think it's going to be too stressful for them. While that's a bit of a noble goal, it's unfortunate that kind of gets away from the reality as to why litigation is important in the first place.
On the process itself, I mean, we won't get into too much detail on it, but Rule 7 for a litigation guardian, Rule 10 for representation orders, both kind of set out in pretty clear terms what has to happen, both if you're a plaintiff or a defendant, how you get appointed as litigation guardian, who's entitled to apply, when does someone like the children's lawyer, the public guardian trustee, take over that role, typically if there's no one else to apply on behalf of someone. So if you are in a circumstance where you're thinking you have to appoint a litigation guardian or get a representation order, look to both rules, either Rule 7 or Rule 10. And it'll set out the general process of, what you need to do, and, what steps you need to take for the court to make sure that you actually have authority on behalf of the incapable person to represent their interests and bind their interests in any proceeding.
Exactly. Well said.
All right. Well, I think that takes us to the end of our podcast today. Thank you for chatting today, Garrett. And I guess until next time, I'm Stuart Clark.
And I'm Garrett Horrocks.
Thank you very much for listening.
Thank you.